afternoon, my lords. Can we pick up one step again? So we're in the First Authorities Bundle, tab 11, page 303. And I showed you subparagraph 10 just before lunch, and I emphasised the point about where the breach of contract results in the loss of a valuable asset created or protected by the right which was infringed. Can I also show you paragraph 12? So common law damages for breach of contract are not a matter of discretion. They're claimed as of right, and they're awarded or refused on the basis of legal principle. And then we see that reflected in paragraph 97 just below. So the Court of Appeal was mistaken in treating the deliberate nature of the breach or the difficulty of establishing precisely the consequent financial loss or the claimant's interest in preventing the defendant's profit-making activities as justifying the award of a monetary remedy which was not compensatory. The idea that damages based on a hypothetical release fee are available whenever that's a just response, that being a matter to be decided by the judge on a broad brush basis, is also mistaken. The basis on which damages are awarded cannot be a matter for the discretion of the primary judge. And so we do rely on that finding. If we now go back to the key passages, I've shown you the conclusions of Lord Reed, and if we go back to the key passages in the judgment, so if we take it from page 282 of the bundle, you have the heading user damages in tort, and you have the principle in paragraph 25 being the general principles that damages are compensatory. In other words, putting the person in the position they would have been in had he not sustained the wrong for which he's now getting his compensation. And if we go over the page, if we start on paragraph 26, so Lord Blackburn's principle can readily be applied in situations where some tangible loss has been sustained. For example, where real property has been damaged or taken by a trespasser, where goods have been converted. Its application is less obvious in situations where there's been an invasion of rights to tangible, movable or immovable property, but there's been no pecuniary loss or physical damage to the property in question. Nevertheless, where a trespasser has made valuable use of someone else's land without causing any diminution in its value, the landowner has been held to be entitled to damages, measured as what a reasonable person would have paid for the right of the user. Damages are also available on a similar basis for patent infringement and breaches of other intellectual property rights. And so again, we emphasise invasion of rights to tangible, movable or immovable property. And you see at paragraph 27, that Lord Reed refers here to Lord Shaw's speech in Watson and Laidlaw. And as I'll show you, he returns to it later. And Lord Shaw says, by letter E, that the principle of user damages is applicable not only to patent cases, but wherever an abstraction or invasion of property has occurred. And then we have the same theme in Rootham Park. You see that at paragraph 28. So it's about an abstraction or invasion of property. And then you have at paragraph 29, the court considers cites Was as being consistent. So Lord Reed cites Was as being consistent with his conclusion about the availability of user damages. So there's no hint here that Was is wrongly decided or still less overruled. And then at paragraph 30, in these cases, the courts have treated user damages as providing compensation for loss, albeit not loss of a conventional kind. Where property is damaged, the loss suffered can be measured in terms of the cost of repair or the diminution in value. Where, on the other hand, an unlawful use is made of property and the right to control such use is a valuable asset, the owner suffers a loss of a different kind, which calls for a different method of assessing damages. In such circumstances, the person who makes wrongful use of the property prevents the owner from exercising his right to obtain the economic value of the use in question, should therefore compensate him for the consequent loss. Put shortly, he takes something for nothing for which the owner was entitled to require payment. And now just pausing here, we emphasise the words, the right to control such use is a valuable asset. And what all of the proprietary torts have in common is providing a cause of action in relation to property rights, freestanding property rights, as Lord Justice Phillips put it earlier. And in contradistinction, competition law does not protect property as a valuable asset, and that really is a touchstone, a key distinction in our submission between the damages available for competition law and the damages available for the proprietary torts, and in certain cases for breach of contract. The proprietary torts and breach of contract, the right that's been breached is a right which protects property as a valuable asset. Then moving on, in the judgment, and then I should say that in the same paragraph, you see again reference to preventing use of the property, and again preventing the ability of the property owner to exercise their right to obtain economic value from use. And you have my point that in this case there's a contract between Meta and class members, so they haven't been prevented from exercising control. Their complaint is that they don't like the terms of the contract. Now, can we skip forward to page 301? So I want to show you Lord Reed's conclusions in relation to contract law. So what I'm skipping over is an analysis of Rutan Park and Blake and so on, and how the extent to which negotiating damages are available in contract cases. And if we look at paragraph 91, you see this at letter D. There are certain circumstances in which the loss for which compensation is due is the economic value of the right which has been breached, considered as an asset. The imaginary negotiation is merely a tool for arriving at that value. And that comes back, 2 points to make here. The second point, the imaginary negotiation is merely a tool for arriving at that value, comes back to some of the questions Lord Justice Green was putting to me at the outset about the Nash bargaining model. So that might be a tool for arriving at the value, but the conceptual loss is not pecuniary loss. And also you see that user damages are available where the right which has been breached is protected as an asset. And again, we emphasise those words. And then, could I just ask the court, could you read to yourselves paragraphs 92 and 93, and then I'll make a couple of submissions.
Can I just ask you what your point is on 91?
Yes.
What Lord Reed is referring to here as the difference between the two scenarios of negotiating.
Yeah.
But he doesn't seem to think there is a distinction. It's a distinction without a difference, as I read this paragraph. Is that right?
What a distinction, sorry.
Without a difference.
What distinction do you have in mind?
Between the two ways of contract negotiating. A hypothetical release, he says that impression of fundamental incompatibility is potentially misleading. So that the imaginary negotiation and an actual negotiation.
Yes, so he's saying that the imaginary negotiation is a tool for arriving at user damages. It's not. It doesn't tell you that what's being sought is conventional damages.
Yes.
Yeah.
So he's not in any way suggesting that using this imaginary negotiation is inappropriate.
No, he's saying that that's a tool that the court, that the courts often use to assess negotiating damages. Yeah. So he's not saying it's inappropriate, but he is distinguishing between negotiating damages and counterfactual damages, if I can put it that way.
Okay.
And then you see the real question. So at the end, the real question is as to the circumstances in which that value constitutes the measure of the claimant's loss. That's the question that's being addressed in one step. And then could I just ask you as to that to read paragraphs 92 and 93? So again, you see at 92, he's saying that the circumstances can exist in cases where the breach of contract results in the loss of a valuable asset created or protected by the right that was infringed. And that's, again, we say critical. And he then says that that characteristic is shared with Lord Shaw's second principle and Lord Justice Nichol's user principle. So he's drawing an analogy with user damages in tort and in tort, and he's saying that that shares an important characteristic. So in each case, so for the proprietary torts and for this category of contracts, what's being protected? So the tort or the contract protects property as a valuable asset in its own right, and so the claimant is being deprived of that asset, and the defendant is, in a sense, taking for something for nothing. And so just thinking about those points, again, we say that competition law does not protect property as a valuable asset in its own right. That's not the function of the competition laws. I'll come back to this. In the same way, so by contrast with the proprietary torts and this category of contracts which give rise to user damages, and you can see at paragraph 93, Lord Reid is saying, well, in a sense, you could describe any contractual right as an asset or indeed as property, but that would be the wrong way to look at it.
But the problem here isn't the nature of the right, is it? Let's imagine I managed to inveigle my way into someone's computer and then take all of the data as to what websites they're looking at, etc., all that off-Facebook data. There'd be some sort of tort committee would be doing that.
There would.
There'd be no problem, you'd say, with what you'd accept in the user damages being claimed for breach of that tort.
Exactly,
tort.
but not competition law.
And your point, I think, is it's not the defendant taking something for nothing here. It's acquiring something for nothing, but it's acquired it pursuant to a contract. And you would say that the fact that it's wrongful because it's a breach of dominance, an abuse of dominance, isn't good enough.
Exactly, that's exactly what we say.
Why? I understand that the other torts, ancient in their history though they are connected to property rights. But you can, within the compass of an abuse, have an abuse in relation to a property right. It's within that compass, isn't it?
Well, no, let me explain why not. But first of all, can I just preface it by saying that, in a sense, in relation to contract, that's exactly the point that's being addressed at paragraph 93. What's being said is, well, in a sense, you could say in respect of lots of contracts that it's interfering in some way with assets or property, but that isn't the touchstone. And what we say about competition law is it's not protecting any property right. What it's doing is it's imposing a regulatory obligation on undertakings not to distort the market by acting anti-competitively. Now that gives rise to a concomitant right on the part of people that have been harmed by market abuse to claim damages where they've suffered loss. But it's not a right, it's not a property right, and it's not a right individual to any property owner. It's an economic right enjoyed by everyone that's been harmed in the conventional sense by the economic practice. So competition law is not protecting property as an asset. So take this case.
It can do in extreme cases.
Well, this is said to be an extreme case.
But do you accept in theory it can do in an appropriate case?
No, because what we say is, let me take this case, then I can go back to maybe the example put to me by Lord Justice Zacaroli. So take this case. The complaint is that there's a contract between consumers and Meta's charged an unfair price. So the right conferred by competition law is the right not to be charged an unfair price. That's what competition law is.
In relation to the property?
Not to be charged an unfair price, yes, exactly. So the terms, it's the terms of the contract that are said to be unfair and abusive. And the class representative has pleaded a claim for conventional loss. So they say, in the counterfactual, we would have been paid money because we were letting Meta use our property. Now, if the CAT decides that class members have not suffered any loss because Meta would not have paid them in the counterfactual, we say, well, that's the end of it. And there's no difficulty with that, because what competition law is doing is providing a right for compensation where you've been charged an unfair price. If in fact you haven't been charged an unfair price on any conventional basis, then that's the end of the story. There's no difficulty with that, because there are cases, as the court will be aware, where the courts have found a breach of competition law which may not lead to an award of damages. We've cited the Carbo case at paragraph 55 of our skeleton argument. And as Lord Justice Zacaroli put it a moment ago, it would be open to consumers to bring a claim in tort. They could say, if they think that their property's been taken without permission, for example, they could bring a claim in tort for invasion of their property rights. But they haven't done that. They've chosen to frame this as a competition claim, and a competition claim in which they say the contract they've entered into is unfair because they've been charged an unfair price. So it's about the terms of the contract. So the question isn't, and our answer to that is that competition law does not protect property as an asset. That's the function of these other torts. It doesn't protect property as an asset. What it does is it gives you the right not to be charged an unfair price. That's how they've put their claim. And if you have been charged an unfair price, you'll get your conventional damages.
In relation to both abuse and cartels, the European case law makes clear that you can have infringements in relation to the use of a patent. Non-compete, non-challenge, tying clauses. Competition law does regulate the use of a patent, and if someone uses a patent in a license and does so unlawfully, damages could flow from it.
If you've suffered conventional loss, but not otherwise. We haven't found any case where user damages have been available. And if
your point is, I mean, my point's slightly different. I'm addressing the question whether competition law can protect property rights or regulate property rights. And you say it's there simply, it's a duty, regulatory duty and an undertaking not to distort the market. That's a very broad brush, correct description, but within that broad umbrella, there can be a sliver of it called regulation of property rights.
There can be. So the example that you're putting to me might be a patent holder abusively brings patent infringement cases to try and drive someone else out of the market. And so you're right that those competition law can say, well, that practice is abusive. That's exploitative. And in those circumstances, if the defendant has suffered pecuniary loss, then they can get damages. But the question here is something else, which is whether this narrow exception, which recognises that where pecuniary loss, where counterfactual loss has not been suffered, the law recognises or will make an award of compensation to reflect the loss of control of property, whether that can happen in a competition claim. And we say not, because competition law is not protecting property as an asset. And in a sense, when one thinks about how damages in competition law have been driven forward, they've been driven forward by, as my lord, you'll know very well, thinking back to cases like Courage and Crean, by EU law and the principle of effectiveness. And it is in our submission telling that when you look, let's just pick up the damages directive. So if we go to Authorities Bundle 5, tab 64.
Just whilst we're doing that, Courage and Crean was cited by Mr. Justice Lewison in Devonish as support for the proposition that damages had to be effective and non-discriminatory, and actually national courts might have to adopt a slightly more flexible approach to damages than they did in their traditional common domestic law. Do you accept that principle applies to Section 18?
Well, what I say about that is that my learned friend has not advanced a point on the principle of effectiveness directly, and he could not do so because it's very clear what is meant by what the limits of the principle of effectiveness are. We can see this from the damages directive. So if you go to tab 64, it starts on page, if we go to page 2273, this is headed right to full compensation. So this is explaining what the principle of effectiveness requires member states to do. Member states shall ensure that any natural or legal person who has suffered harm caused by an infringement of competition law is able to claim and to obtain full compensation for that harm. And then 2, full compensation shall place a person who has suffered harm in the position in which that person would have been had the infringement of competition law not been committed. It shall therefore cover the right to compensation for actual loss and for loss of profit, plus the payment of interest. And so you can see what EU law says has to be available for breach of competition law. Now, my lord will put to me, well, member states are not precluded from going further, and you'd be correct to say that. Member states are not precluded from going further if their national law requires it. But you have my submissions, which I haven't yet completed, on why national law doesn't require it, because the principle of user damages, the rationale for it, doesn't apply to competition claims.
Just going back to Courage and Grin, I see what you say about Article 3. I don't think you quite answered the question. Do you accept that the principle in Courage and Grin applies to Section 18 as it stands today? And does it stand in front of the cat?
No, I don't accept that the principle of effectiveness applies in a freestanding way post-Brexit, but I don't think it matters in this case. Because I
well,
don't...
it might do if, I mean, it may be this case ultimately boils down to an extremely unlikely scenario, which is the cat finds exploitative and unfair abuse. It does so by reference to a counterfactual, but it at the same time can't find, for whatever reason, some form of compensatory loss. Yet it still feels there's some gap or lacuna which it wants to remedy by something else. And it then said, well, what about user damages? Now, that might be a remarkably improbable scenario, because if you get that far, they may have lost on abuse, because in the counterfactual, but that's almost the predicate that we're now facing.
That's the predicate. I agree that's the predicate. And
maybe
the flaw,
highly unlikely, but
that's the predicate.
Would we strike it out, given the extremely complex scenario that we're contemplating in a competition case?
My lord, we say yes, and the reason why, you're right that that's the predicate, so I accept that. But the flaw in what you're saying is that this is not some sort of discretionary remedies I showed you in paragraph 95.12 and paragraph 97. So it's not the case that if conventional loss is found not to have doesn't exist, so if there's no actual loss within the meaning of Article 3, that the cat has to strive to make a remedy. That's not what competition law is about.
I'm not certain on this predicate it's striving. We start with the premise that it has found value exchanges to be subject to something unfair and exploitative, yet it can't, for reasons which may be beyond us all, conclude that there is in a counterfactual somewhat discernible loss. Yet, again, it may be highly improbable, it feels there's a gap. And it says, well, we could do this actually by the following piece of evidence, which is a counterfactual bargaining analysis a la Nash.
Well, my lord, to that we say that approach, if that's the approach the cat takes, that would be wrong in principle, because what's very clear from one step is that there has to be, and we see this in paragraph 97, it's not a matter for discretion on the part of the judge. There has to be an interest that's recognised by law as deserving of an award of user damages.
But it has, because it found abuse in relation to value, and it simply decided on ordinary compensatory principles it can't come to some monetary quantification. I mean, it may be hard to imagine a scenario where that would be the case, and you may be absolutely right. If you get to that point, they've lost anyway.
Well, no, my lord, it's a more principled objection we take. So we say that if they've made a claim for unfair price, if they can't establish that in fact consumers have suffered any pecuniary loss, then what competition law gives them
Then you've won on abuse, haven't you?
Sorry?
Then you've won on abuse, if that's the conclusion.
No, not necessarily, because you could have a scenario in which the scenario that no doubt is the predicate for them making this pleading, this amendment, is that they've won on abuse because it's found that the terms are unfair in some way. Perhaps they're not transparent enough, by way of example. And in the counterfactual, the terms would have been different, but in the counterfactual, Meta would not have made a payment such that there's no loss, no pecuniary loss that's been suffered, no counterfactual loss. And in those circumstances, the question for the tribunal will be, as a matter of principle, not can we fill a gap, but as a matter of principle, does competition law require an award of user damages to reflect the fact that Meta has had use of this data? And we say no, because competition law does not protect. There is no freestanding property claim or right that's being invoked.
This is the absolute essence of this appeal,
This is the essence of the point.
So does competition law have an interest in intervening in those circumstances? A legitimate interest?
Not a policy interest, or it's not does it have an interest, it's does the rationale for the exceptional award of user damages, does that apply in competition cases? And we say it doesn't. And we say it doesn't for two related reasons. One is because the rationale, the court is quite clear that that user damages arise where the right that's been breached protects property as an asset, and we say competition law doesn't do that. And then secondly, we say that what's going on in this case, which they say is one of those exceptional cases in which competition law should attract user damages, is they are complaining about the terms of a contract to use property, and that's completely anathema to the rationale for user damages in tort as set out in the cases. I haven't got much time left according to the timetable I've agreed with my learned friend. I need to take you to Lloyd Google. But I think this exchange has been very useful in distilling the essence. And that's why, as I say, the court should, in response to Lord Justice Phillips' point from earlier, why the court should grasp the nettle now, because we do say it's a point of principle about the rationale for user damages and how that does not apply in this case, in competition cases, or indeed in this case. So, now, I think the final thing I need to do is show you Lloyd Google. So that's behind tab 13 of the First Authorities bundle. And this was a proposed representative action against Google under the Data Protection Act. And the claimant sought damages under section 13 of the Data Protection Act without proof of material damage, and also sought user damages. And we see that from page 383 of the bundle, at paragraphs 88 to 89, which I've just effectively summarised. But there are 3 points that we take from this case, and again, I'll summarise them and then take your lordships to the relevant parts of the judgment. The first is a relatively minor point, and it's that Gulati was not in terms decided on the basis of user damages, and that's an answer to my learned friend's point I showed you in his skeleton on Lady Justice Arden's judgment in Devonish being inconsistent with Gulati. It's a relatively small point. The more important point, so the second point, is that the availability of user damages in tort is dependent on the cause of action, which is a point I've been making. And it's wrong in principle to argue that because the facts of the case concern treatment of property or treatment of personal data, that this in itself gives rise to a claim for user damages. A similar argument failed but was rejected by the Supreme Court in Lloyd and Google. And the third point we make is that the approach taken by the Supreme Court to user damages in Lloyd and Google is unsurprisingly the same as that in One Step, namely that they're available where wrongful use has been made, where somebody's property rights have been invaded, and where the cause of action protects that from happening. Now, if we take the first rather smaller point, I'll take the points in that order because that's the order in which they appear in the judgment. So if we start at page 387, you have discussion of Gulati. In view of the time, I'm going to take this point quite shortly, but the court here considered the Court of Appeal's judgment in Gulati. The claimant was, in Lloyd and Google, relying on Gulati in support of an argument that damages under section 13 of the Data Protection Act were available without proof of damage. Gulati was a misuse of private information case. And you can see from paragraph 100 that the trial judge, Mr. Justice Mann, had held that distress was not the only touchstone for damages. And he said there's no reason in principle, I'm looking beside letter F, why the court should not also make an award to reflect infringements of the right itself. And then at 102, paragraph 102, the Court of Appeal affirmed that decision, and you can see the justification is that privacy is a fundamental right. And so, pausing here, you can see that even though the rationale for damages is expressed to be the deprivation of the right of the claimants to control the use of their personal private information, so the same rationale as that for user damages, the court never referred in terms to user damages. Instead, the justification was said to be that privacy is a fundamental right. Now, we don't need to turn up the judgment in Galati as the salient parts are summarised and quoted here, but it is striking that WAS was not cited or referred to, and there's no reference to any of the user damages cases, and that's really the short answer why the point at paragraph 46 of my learned friend's skeleton argument is wrong on interpreting Lady Justice Arden's judgment in Devonish. But more positively, the more positive point we take from this is that, again, the justification from both Mr. Justice Mann and the Court of Appeal was that an award of user damages, or something akin to user damages, should be made because the cause of action protected property as a valuable asset in its own right. Now, if we turn on to page 389, you see that what the claimant was arguing, this is paragraph 108, is that the claimant seeks to break new legal ground by arguing that the principles identified in Gulati also apply to damages under the Data Protection Act. So that's what they're arguing. And then you see at page 390, you see something called the common source argument being referred to. And can I just ask the court just to read paragraph, well, we can see the end of paragraph 111. The common source argument is both seek to protect the same fundamental right to privacy guaranteed by Article 8 of the Convention. And can I just ask you to read to yourselves paragraph 112? Now, the court rejects the argument that because the Data Protection Act is seeking to protect private information, that damages should be the same as the damages available for the tort of misuse of private information, such that something like user damages could be available. And they rejected it because they said, well, it doesn't just follow from that. You've got to actually construe the statute and decide what damages Parliament intended to be available for breach of the Data Protection Act. And then if we move forward, please, to paragraph 124 on page 393. If I just ask the court to read that paragraph to yourselves, para 124. Particularly from letter H. So, in other words, the availability of user damages is properly tied to the specific cause of action that is advanced. User damages are not available merely because the pleaded factual allegations are said by a claimant to be analogous with factual allegations which could in principle be pleaded so as to advance a different cause of action in which user damages are available. You can't extrapolate from one to the other. So it's not the facts of the case that are key. It's the cause of action. And here, of course, you have my point that the facts of this case, of the present case, are in any event not analogous to facts that could give rise to a cause of action in the proprietary torts. That's because of the critical distinction that I identified at the outset, that there's an agreement between users and Facebook as to use of their data. Now, of course, every statute needs to be interpreted on its own terms, but we say that when one is interpreting the competition rules, there is no basis on the face of the competition rules or in any of the authorities or in the damages directive to suggest that user damages are available. And I've made my points on that. And they are points about the purpose of the competition rules to being to prevent distortions of competition in the market, and not critically not being to protect property as an asset in its own right. Then if we turn, the court then goes on to consider the claim for user damages. So we've moved on from the DPA. And if we go to page 397 of the bundle, you see paragraph 139. Can I just ask you to read paragraph 139 to yourselves? So again, wrongful use of land or tangible movable property, purpose being to compensate the claimant for interference with a right to control use. None of that arises where there's a contract. And then 141, at the top of page 398, a claim in tort for misuse of private information based on the factual allegations made in this case would naturally lend itself to an award of user damages. The decision in Gulati shows that damages may be awarded for the misuse of private information itself on the basis that, apart from any material damage or distress that it may cause, it prevents the claimant from exercising his or her right to control the use of the information. So again, we emphasise the words prevents. Nor can it be doubted that information about a person's internet browsing history is a commercially valuable asset. So again, the class representative places weight in her skeleton argument on these dicta of the Supreme Court in relation to misuse of private information. But in our submission, they assist us because they are of a piece with one step, and indeed of a piece with WAS. And they show that the rationale for the availability of user damages for the proprietary torts applies in a similar way to misuse of private information, because the tort of the misuse of private information protects information as a valuable asset. And where that right has been breached, then the claimant has lost, it's prevented the claimant from exercising their own control. Not the case here, because competition law does not protect property as a valuable asset in its own right. And here you have my submission that there is a contract. So class members have not been prevented from controlling their information. They just don't like the terms of the contract.
Can you just... First of all, when I read these paragraphs, there's an extension from 139 which refers to tangible property to information.
Yes.
So it's intangible by the time we get to 141. And then one's got this statement in 142, which, towards the bottom half of 142. The words moreover, just above E, where the defendant's very purpose in wrongfully obtaining and using private information is to exploit its commercial value. The law should not be prissy about awarding compensation based on the commercial value of the exercise of the right. So the wrongful extraction here would be the abuse, or could be part of the abuse. The abuse was to exploit the commercial value of the information. And the Supreme Court says the law should not be prissy about awarding compensation based on commercial value of the exercise of the right. Doesn't that apply here?
Well, no, because in that case, the allegation, so there was no contract. The allegation was that data was just taken without anybody knowing about it at all, so there was no contract. But what you see at the beginning of 143 is this: the point does not arise in the present case, however, because the claimant is not claiming damages for misuse of private information. It's making a claim under the DPA. And so none of those points assisted, that my Lord's just taken me to, assisted in demonstrating that these damages were available under the DPA.
Are you saying they're obiter? 142?
No, well, it is strictly obiter, but I'm not seeking to, my point's a more profound one. It is obiter, but that's not my point. My point is that the points that you've, my Lord, taken me to, so the law should not be prissy and so on, they only go so far. So they establish that that Lord Legate thought that and I accept, that user damages are available for the tort of misuse of private information. And you can see that the basis of his reasoning there is reasoning by analogy. We see this in 141, from those cases in which they are available, and he's referring to those in 139. So he says, by analogy, damages are also available in cases of, for the tort of misuse of private information, because it is adjacent, it's analogous, and that's because the same rationale applies, because where that tort is committed, that tort protects information as an asset, and where it's committed, it prevents the claimant from exercising his or her control to the use of the use of information. Then he's saying, well, it might be, you might have various objections to it, but I'm not those objections I'm not persuaded by. But then critically, he says at 143, well, that helps you in relation to the tort of misuse of private information. So your facts that you're complaining about, you could advance a claim for user damages for misuse of private information. But what you can't do is use the same fact, is say, aha, damages are available on the same facts for misuse of private information, therefore they must be available under the DPA. You can't do that. You've got to look at the cause of action in its own terms. So the fact that the fact pattern might be the same, or the facts might be the same, that you might on the same facts be able to make a claim for user damages for breach of the tort of misuse of private information or detenue or conversion, doesn't allow you to simply recycle the same facts in the context of a claim under the DPA, and we would say in the context of a claim under the Competition Act. So that's really the point.
You could be right. Our question is whether, for the purpose of mission to amend a pleading, it's at least something we think the CAT ought to grapple with later. This is quite a broad statement. You may be right that it has to be read in context and narrowed down and so on. Does it prevent the amendment of a pleading so the issue can be explored on this very extreme predicate that we now seem to be focusing upon?
Well, my lord, my submission is one of principle. So we say it's not reasonably arguable because look at these cases. The touchstone, the rationale for the availability of user damages does not apply in competition claims or in this case. And I've given you the two reasons for that. It is notable, and we would emphasise, that these touchstones are consistent through the case law. So WAS, One Step, all of these dicta going back are concerned with protection of property as a valuable asset in its own right. And we say, number one, that's not what competition law is doing. You have my submission on that. And we say, number two, they are concerned with a situation where the breach of the various rights that give rise to user damages prevents consumers from dealing with their assets at all, from exploiting them at all. And we say, no, because here you have a contract and it's about unfair terms. And so we do say that this has been constructed as a competition claim in the CAT. And the claim is one, essentially, for an unfair price. And if they can't establish based on a counterfactual analysis that they have been charged an unfair price, that's all that competition law requires in terms of damages. There is no basis in the rules to say, oh well, competition law is also protecting property as a valuable asset in its own right, so user damages are available. Now, if we're right on that, it simply doesn't matter what facts come up at trial, and it is extremely telling, we say, that nobody, neither the tribunal nor the class representative, has even identified any facts that could move the dial on that question of law. And if we're right on that question of law, we're going to be back before you in 2.5 years' time making exactly the same arguments. So
I think this case might be back before us in any event. I've just got this sneaky feeling.
And you have my point that the issue should not be determined if and only if they lose their claim to conventional damages. It does turn on a conceptual point of principle. And either we're right about that or we're wrong. Of course, we say we're right. But there's no, if we're right, there simply is no good reason to defer deciding the point. Those are my submissions, unless you have any further questions.
Thank you very much indeed.
I'm grateful, my lord. Having reflected on my learned friend's submissions this morning and this afternoon, this appeal, we would suggest, raises two distinct issues for your lordship's determination. First is either Devonish or One Step binding authority in Meta's favour that precludes an award of user damages in this case. That is issue 1. Second, if Meta were to fail on issue 1, so if your lordships were to conclude that there's no binding authority in Meta's favour, is there some other reason why the tribunal was wrong to permit the amendment? That is issue 2. And the reason why I distinguish between those two issues in that way is that if Meta were to fail on issue 1, so if your lordships were to take the view there's no binding authority either way, then in our respectful submission it's not easy to see how Meta could seek to go behind the tribunal's case management decision that the availability of user damages in this case is unsuitable for summary determination. Not least because, my lords, it is common ground that a trial will be required in any event. It is common ground that the amendment will not affect the length of the trial or preparation for it. And the tribunal found that this amendment concerns an evolving or developing area of the law, and these are points that my Lord Justice Phillips put to my learned friend, and I'll need to return to them. But those are, as we see it, the two distinct issues that arise for your lordship's determination. In terms of the batting order for my submissions, what I propose to do, subject very much to the court, is to address 3 topics. First, I want to deal with the legal nature of and the rationale for user damages, which has become, in the light of my learned friend's submissions, an important battleground in this appeal. What's the legal nature of user damages and what is their rationale? Having done that, I will then deal with issue 1, which is there binding authority in my learned friend's favour? And then with issue 2, which is there some other reason why the tribunal is wrong to permit the amendment? So subject to your lordships, that's the proposed running order, as it were. And if I can then turn to the first of my 3 topics, which is what is the legal nature of and rationale for user damages. Taking first the legal nature of user damages, we advance 4 propositions, one of which is common ground, whereas the other 3 are not or may not be. Proposition 1, which is common ground, is that user damages are compensatory in nature. Not restitutionary, but compensatory in nature. And I say that's common ground because it's accepted in paragraph 29 of my learned friend's skeleton argument. Proposition 2 is that user damages in our submission constitute compensation for loss, albeit loss of a different kind to which normal damages are awarded. But user damages constitute compensation for loss. Third, and perhaps most importantly, contrary to what my learned friend submitted at draft transcript, page 3, lines 13 to 16, I suspect these references will change when the transcript is finalized, but your lordships will recall a submission made, I think, more than once, that user damages are an exception to the ordinary compensatory principle. That, with respect, is not right, and there's Supreme Court authority that demonstrates that. User damages in our submission represent an application of the normal compensatory principle, not an exception to it. So that's proposition 3. And proposition 4, which my Lord Justice Green raised with my learned friend just a few minutes ago, is that although user damages can be measured by reference to a hypothetical negotiation, that is only a valuation tool, and it does not change the legal nature of user damages. Now, as I said, proposition 1 is common ground, so I don't need to say anything more about that. 2 to 4 are not, but we submit that all of them can be derived actually from the 2 leading Supreme Court cases on the point, namely One Step and Lloyd and Google. And can I show your lordships that? Starting with Lloyd, because it's fresh in the mind, my learned friend having just gone to it. That's Authorities Volume 1, tab 13, page 350. And if I can invite your lordships, please, to go to para 156 at page 401. So volume 1, tab 13, page 401. Para 156, Lord Leggett says this: as explained in Morris Garner, the object of an award of user damages is to compensate the claimant for use wrongfully made by the defendant of a valuable asset protected by the right infringed. The starting point for the valuation exercise is thus to identify what the extent of such wrongful use actually was. Only then can an estimate be made of what sum of money could reasonably have been charged for that use, or put another way, for releasing the wrongdoers from the duties which it breached in the wrongful use that it made of the asset. Imagining a hypothetical negotiation, as Lord Reed explained at para 91, is merely a tool for arriving at this estimated sum. And then it's really this sentence that we rely on, and just contrary to my learned friend's argument. As in any case where compensation is awarded, the aim is to place the claimant as nearly as possible in the same position as if the wrongdoing had not occurred. That, of course, is the classic compensatory principle articulated in Livingston and Royart's Coal Company. And what, as we read para 156, Lord Leggett is saying, is that user damages represent an application of that same compensatory principle. And indeed, one sees the same point made in One Step itself. If I can show the court that, but I can do so more briefly because my learned friend went to it. It's in the same bundle behind tab 11 at page 282. Now, it is significant in our submission that just above para 25, where Lord Reed commences his analysis of user damages in tort, he does so by taking as his starting point the ordinary compensatory principle articulated by Lord Blackburn in the Livingston case. So that's what he starts with. He then discusses cases in which that principle has been applied, starting with infringement of property rights. Then at 27, he deals with patent infringement, and I need to come back to that case, the Watson-Laidlaw case, which is important. And then at paragraph 30, Lord Reed says that in these cases, so the cases he's been discussing in the preceding passages, the courts have treated user damages as providing compensation for loss, albeit not loss of a conventional kind. Where property is damaged, the loss can be measured in terms of the cost of repair, the diminution in value. Where, on the other hand, an unlawful use is made of property, and the right to control such use is a valuable asset, the owner suffers a loss of a different kind, which calls for a different method of assessing damages. And the use of the word method is perhaps significant, because what Lord Reed is saying is that all that is different about user damages is the method, not the objective, which remains to compensate the claimant.
Well, it does say it suffers a loss of a different kind.
Yes.
But it isn't just the method.
No, I accept that it's loss of a different kind. What I mean is that the objective of an award of user damages is the same as the objective of an award of normal damages, that objective being to restore any loss that the claimant may have suffered. The difference is it's loss of a different kind, the loss being the deprivation of the ability to exercise a right to control the use of some identifiable asset. Indeed, a point has often been made, my lords, that one of the problems about this area of the law is terminology, because you get lots of different labels to describe the same concept. And one could equally describe user damages as loss of control damages, because that's what it's about. What it is providing compensation for is the wrongful deprivation of a right to control the use of an identifiable asset. That's why it's loss of a different kind. It's not that you are worse off than you would have been in a narrow financial comparison of the counterfactual and actual worlds. It is that you've been deprived of something that inherently has value, namely the right to control the use of an identifiable asset. I'm going to come back to that because that's an important point. But that's what we say about the legal nature of user damages. Now, the other point I wanted to pick up, arising out of my learned friend's submissions on this morning, is when do you get user damages and why do you get them? Because, as my Lord Justice Green observed, that's really at the heart of this appeal. Do you get them for a reason that is foreign to competition law, if I can put it like that? Now, it is common ground that on the current state of the law, there are various causes of action for which user damages are available. For example, trespass, conversion, detinue, patent infringement, misuse of private information, breach of confidence in equity, and certain types of breach of contract. But one question your lordships may wish to ask, we would suggest, is there some principle or rationale that explains why user damages are available for these causes of action? What, if anything, do they have in common that makes them suitable for user damages? It's the answer to that question which is in dispute. And before I address them, can I just identify the rival answers which have been put forward before your lordships? We say that the unifying principle, identified by the Supreme Court in One Step and Loyal, we say that the principle is that user damages are available at common law if the defendant wrongfully used property or some other identifiable asset and thereby prevented the claimant from exercising a right to control the use of that asset. Because it takes a while to say that, I'm going to refer to it as shorthand, if I may, as the wrongful use principle. On our formulation, that is the principle which determines whether you get user damages. And what is significant about that formulation, if it is correct, is that the availability of user damages would depend on the substance of the right infringed in an individual case, and not on the source of the right or its legal classification. So on our analysis of the law, which obviously I need to make good, on our analysis of the law, it is the substance of the right infringed which determines whether you get user damages, not where the right comes from. It might be contract, it might be property, it might be statute, but what matters is the content of the right, not its label. So that's, as it were, our case, which, as I say, I need to make good. The rival answer, which is my learned friend's case, is that at least in the law of tort, you can only get user damages for what she describes as proprietary torts. Now, one question is what that means. I mean, there isn't, as it were, a definition of what a proprietary tort is, but more fundamentally, there are, we would respectfully suggest, various difficulties with seeking to limit user damages in the law of tort to proprietary torts. The first point is this. Before we look at the authorities, one might ask, why as a matter of principle would there be a rule that you can never get user damages for a non-proprietary tort? What would the justification for that exclusionary rule be? In the first of its two skeleton arguments before the CAT, Meta did seek to answer that question. They said the reason why you can never get user damages for a non-proprietary tort is that user damages are only available to protect non-financial interests. Just to give your lordships a reference, I don't think we have to turn it up, but that submission was made by my learned friends at paragraphs 43, subparagraph C, and paragraph 50 of their first skeleton, which is supplemental bundle, tab 6, pages 53 and 57. But there were always difficulties with that submission, which was not maintained by Meta in its second skeleton. The difficulties include the fact that there are a number of cases in which user damages have been awarded for the infringement of a right that protects purely financial interests. One example is patent infringement, for which it is, I think, common ground user damages are available, even though, as Lord Sumption pointed out in the one-step case, that's, just to give the court a reference, para 119 at Authorities, Volume 1, tab 11, page 313, Lord Sumption pointed out that a patent protects only the financial interests of the patentee. That's the purpose of a patent. And another example is the very passage my Lord Justice Green asked my learned friend about, para 142 of Lloyd and Google, where Lord Leggett makes the point that if information with a commercial value is wrongfully taken, the law should not be prissy about awarding compensation, recognizing that the fact that the interest protected is financial is no objection to the award of user damages. Now, in fairness, my learned friends don't maintain that before your lordships. They don't say in their appeal skeleton that you can only get user damages for your rights that protect financial interests. Instead, as I understand it, the justification now put forward is user damages are exceptional. They're an exception to the normal compensatory principle. Your lordships have my submission, that's not right. It's contrary to para 156 of what Lord Leggett said in Lloyd. But more generally, it's left Meta without any argument of principle for why user damages should be confined in that way. So that, we would suggest, is the first difficulty about the exclusionary rule. The second is, let's assume in my learned friend's favor that the exclusionary rule does exist, so you can never get user damages for non-proprietary tort. That would immediately bring the law of tort in tension with the law of contract. Because if one thing is clear after One Step and Morris Garner and Lloyd Google, it is that you can get user damages for certain breaches of contract which are not only not proprietary, but which are not even analogous to property. The most striking example of that is probably the Supreme Court's analysis of an earlier case called Experience Hendricks, which we have in abundance, but just to save time and to summarize the facts. What happened in Experience Hendricks was the claimant was the estate of Jimi Hendrix, who had made some recordings. And what had happened was they had entered into a contract with a company called PPX, under which PPX was prohibited from licensing certain Jimi Hendrix recordings in which the copyright was owned by PPX, not by Jimi Hendrix. So the important point about the Experience Hendrix case is that the claimant had a contractual right to control the use of an asset which was owned not by the claimant but by the defendant, because the defendant was the owner of the copyright. In the event, PPX infringed that contractual right by licensing the recordings without the claimant's consent. That breach caused no conventional loss. So, to use my learned friend's terminology, it caused zero counterfactual loss. And the claim for damages failed at first instance, but it succeeded in this court. And although the Supreme Court in one step disagreed with some of the reasoning of Lord Justice Mance and Lord Justice Peter Gibson, the Supreme Court endorsed and rationalized the result. And perhaps I can show your lordships that. It's Authorities, Volume 1, Tab 11, page 300. So paragraph 89 at the bottom of the page, after discussing the Experience Hendrix case, the discussion starts at 85, and then you get the conclusion at 89 on page 300, where the Supreme Court says, notwithstanding some of the reasoning which they disagree with, the decision in the case can be supported on an orthodox basis. The agreement gave the claimant a valuable right to control the use made of PPX's copyright. When the copyright was wrongfully used, the claimant was prevented from exercising that right and consequently suffered a loss equivalent to the amount which could have been obtained by exercising it. The reason I draw that passage to your lordship's attention is that the success of the claim for user damages in Experience Hendrix can't be explained on any proprietary basis, because the claimant not only did not have a proprietary cause of action, its cause of action was normal breach of contract. It wasn't even analogous to a proprietary cause of action, because the contractual right in question protected somebody else's property, not the claimant's. But that did not prevent user damages from being awarded. And the fact that that's the approach taken in the law of contract, I accept, is not conclusive in my favor, but it is, we submit, at least an indication that the exclusionary rule for which my learned friend contends is unlikely to exist. So that's our second point. The third difficulty we would respectfully suggest with the exclusionary rule is a point I can try to make by reference to some of the discussion this morning. So in this case, what the class representative alleges is that by abusing its dominant position, Meta was able to take and use commercially valuable data of about 46 odd million UK users of Facebook. That must be assumed to be true for the purposes of this appeal, namely the allegation of abuse. Meta's pleaded case in its defense is that even if that abuse is established at trial, users should not receive any compensation because Meta would not have been willing to pay for the data in the counterfactual. And to give your lordships a reference, that is defense paragraph 263, subparagraph B, subparagraph 4, supplemental bundle, tab 13, page 501. So that is Meta's pleaded defense to the existing claim for conventional damages. But Meta also says user damages are ruled out as a matter of law. So that means that if Meta's appeal were to succeed, the consequence would appear to be that it is open to a dominant entity by abusing its dominance to take and use commercially valuable data of users, but avoid making any payment by contending on the one hand that user damages are unavailable because competition law only compensates for counterfactual loss, but on the other hand, that counterfactual damages are also unavailable because in the counterfactual, the dominant firm would not have been willing to pay for the data that it wrongfully took without payment. That would be the consequence. if Meta's case were to succeed. And for our part, we respectfully suggest that's a slightly surprising consequence, which I can try to illustrate by taking the example my Lord Justice Zacaroli put to my learned friend. I think the example was, if you have a dominant entity which says, I won't provide services unless you part with your land, let's say, and assume that that's an abusive bargain. One possible counterfactual, depending on the facts, is that they would have made some payment which removes the abuse. But you could have other counterfactuals. I mean, it may be that the dominant company says, I will simply not provide the service, or I will provide the service in some other way which doesn't involve taking your land abusively. But whatever the counterfactual, my lords, one thing that is clear is that in the actual world, the dominant entity did take the land of the users in my lord's example, and it did so abusively. And that once that is established, one is in the territory of user damages, or at least arguably so. Now, I don't need to go further than that for the purposes of this appeal. I mean, I accepted before the chair, he asked me this question, and I accepted before your lordships. I'm not saying the position is clear-cut in my favor to the summary judgment standard. I don't say that. This is a difficult point in a developing area of the law. But I do say the position isn't clear-cut the other way.
Could you help us at some point, just so that we do understand your pleading?
Yes.
We were obviously vexing Mr. Mitriou about it yesterday, and it's really for you to, I think, explain to us precisely what paragraph 26A
Yes.
is getting at.
Yes.
And the scenario that, again, I was discussing with Mr. Mitriou this afternoon as to what this perhaps quite extreme
Yes.
premise might be. Is that correct in your view? I think we'd like to just understand precisely what the parameters
Yes.
of this particular dispute are by reference to the pleading
Absolutely.
and the assumptions that we have to make to get there.
Absolutely. I was going to do it in some detail, but why don't I give your lordship a brief answer now, and I'll come back to it. It's quite an important point. So I'll go to the pleading in a minute, but your lordships will recall that our pleaded case is that there are two ways in which this abuse occurred, which we say are two sides of the same coin. One is the unfair term, the
The
TO
seller and the buyer point.
Indeed, and the other is the unfair price.
Yep.
Now, we particularize those alleged breaches in various ways, one of which actually is lack of consent, and I ought to show you lordship that.
That's the take it or leave it point.
I'm sorry?
The take it or leave it point.
Take it or leave it, but in particularizing the take it or leave it point, we say the reason why it is to be regarded as a take it or leave it condition, we say various things, including the choice architecture imposed by Facebook, and we actually plead in terms that they were required, albeit for GDPR purposes, specifically to obtain the consent of users for extracting off Facebook data, which they failed to do. And can I show your lordships that? It's the supplemental bundle, the pleading. Supplemental bundle, tab 12, page 203. So S13, the heading above that is abuse. And if we pick it up in the third line in S13, we say that as a matter of legal classification, the abuse in the present case can be looked at in two related ways that in practice amount to the same thing. The first is unfair terms. The second is unfair price. Then 14 identifies the unfair term way of putting the case, which is, as my lord said, it's the take it or leave it point. Because users had no ability at all to avoid or limit the collection of off-Facebook data, or had no effective ability to do so, involves imposing an unfair trading condition. And then over the page, if we look at subparagraph C, we plead in the context of GDPR, which is relevant to the abuse but not necessary to prove it. The processing of data from other websites and apps is not necessary for the provision of social network services or for Facebook's own objectives. Furthermore, separate and specific consent is required for the processing of off-Facebook data under GDPR, which Facebook did not obtain. So that is pleaded. And I also tell your lordship, you'll get a copy tomorrow, that Meta have served an RFI asking us to particularize this part of our case. And we have responded to that RFI, which I don't think is in the bundle, but we'll get your lordships a copy of that. And then we plead the unfair price abuse at S16. And then if we get to 26, which is the point my lord asked me about, that's page 208. Sorry, 209. So 26, it pleads the existing conventional damages case. 26A is the paragraph we were permitted by the tribunal to introduce by amendment. That's the user damages case. And my learned friend is right to this extent. We seek to say at trial, and that's why we applied for leave to amend, that if the tribunal were to accept our case that there was an abuse here, for example, because the term was unfair, there was no effective consent, it wasn't transparent, things of that nature, but Meta's existing defense, namely, we would have chosen not to pay for the data, is for some reason upheld, and it remains to be seen whether it will be or won't be. We say the consequence is not that Meta gets off without paying anything, but at that stage in the analysis, it becomes a user damages case, because the hypothesis at that stage of the analysis is Meta unfairly or wrongfully took commercially valuable data of users. And if our analysis of the law relating to user damages is right, namely that the availability of user damages depends not on the source of a right, but on its substance, then that would be the type of case in which user damages ought to be awarded, irrespective of what would have happened with the counterfactual.
Just, I think you're agreeing with Mr. Dimitriou that the premise, which we have to understand, is that there is dominance, there is abuse, and that in some way, shape or form the tribunal has found that it's unfair and exploitative. It relates to value, probably can't be more specific than that, but that a traditional counterfactual compensatory analysis doesn't, again, for whatever reason, enable the CAT to measure the abuse. In those circumstances, given that there is still an abuse out waiting to be remedied, you move to what we are now calling user damages.
Yep. Precisely so.
That's what we're talking about, and for our part there may be lots of improbable steps along the way, but that's where we're forced to, because if there's no counterfactual loss, it may turn out that there's no abuse. But the premise we're looking at is we've got to this point and there is still an abuse which is unremedied.
Precisely so, my lord. And I don't disagree with your lordship that these issues are closely related and it remains to be seen how they will interact with each other. But the reference I gave your lordships earlier to Meta's defense, where they say that there's no loss, therefore no damages, that defense is pleaded on the footing that the abuse is established. So they don't say because we would not have made a payment, therefore no abuse. They say that. But in addition, they say, even if you establish an abuse, you get nothing because we would have chosen not to pay.
Yeah.
Is this one possible scenario, which draws out this point exactly, that it might be that, because you need to establish a counterfactual to establish abuse, it may be that the relevant counterfactual would be customers would have used a different service, which did not require them to give up this off-Facebook data. In those circumstances, the loss they have suffered is just the fact that their off-Facebook data was in fact taken by Meta.
Yeah.
In which case, their argument would be, well, there's no actual loss there unless you resort to user damages. And it's that scenario where you say we can resort to user damages.
Precisely so. And the reason why we say that is in the way your lordship just formulated it. The fact remains that there is both abuse and a real loss to users, albeit loss of a different kind. That real loss of a different kind being the taking of their off-Facebook data by abusive means. I need to come back to the first part of your lordship's question, which is you only have...
It also assumes that Meta is being provided with raw material for its business, which it makes vis-a-vis advertisers.
Yes.
So it's not as if there's no economic value attached, as Lord Leggett said in Google. There's plainly an economic value attached to the data. It's critical raw material, which you're surviving, and then in return you're getting a service.
Yes.
So the question is, how do you value that material?
Yes.
And there are lots and lots of different ways in competition law you can value something. And that's why, at least part of me is still thinking this is enough more just one additional piece of evidence that you would use to calculate value.
Well, I see what your lordship means. I think what is being said against me by Meta is that if in the counterfactual Meta would not have made a payment, then even if there is an abuse, our claim fails. And we
Yes,
say,
yes.
we say that's wrong as a matter of law. I mean, arguably wrong as a matter of law. I don't need to go further than that. But I need to come back to the other point my Lord Justice Zacaroli raised, which is there a cause of action at all in competition law without a counterfactual? This is a point that was taken below. It's assumed less prominence here. For our part, we say the answer is yes, because, and I'll develop this probably tomorrow, if you look at the classic case, which is probably Garden Cottage in the House of Lords, Lord Diplock, what Lord Diplock says is that if there's an infringement of competition law, that is vindicated in English law through the tort of breach of statutory duty. And an element of that tort is loss. But loss does not mean counterfactual loss, it just means loss, which we know after one step in Morris Garner includes the loss of a different kind, as Lord Reed describes it. So there's no conceptual reason why you can't get user damages in competition cases. I don't say you'll get it in every case. That's never been our case. We advance a very narrow case, which is if in a particular case, property or some other asset is taken through an abuse of dominance, one of the remedies which it is open to the court to grant, if it is appropriate to do so, is user damage. My ambition doesn't go beyond that, and I'll take your lordships to Garden Cottage to make that point good. But just while we have one step open, can I make this additional point? Page 283. I think before the short adjournment, my Lord Justice Phillips asked my learned friend, sought to explore the distinction between absence of consent and vitiated consent. And for our part, we would respectfully suggest that's an important point, because if one looks at the example at the bottom of page 283, quite a famous example in the user damages jurisprudence, as it were, Lord Shaw says, if you take my horse and you ride it without my consent.
I'm so sorry, 283 of...
Oh, I'm so sorry, my lord. It's the authorities. I apologize. It's authorities, volume 1, tab 11,
Yep.
page 283. It's really the example at the bottom of the page, which is saying that if you take my horse and you ride it, it may be that the horse is no worse off and indeed better off because of the exercise, but that is no defense to a claim for user damages. Now, one of the main submissions my learned friend made today is she says there's a sharp distinction between the taking of property and the acquisition of property on terms which are wrongful. But your lordships may wish to test that against this example. So instead of somebody coming along and just taking my horse and riding it, they lie to me and induce me to give them the horse, which they then ride. Is it really the law, we would ask rhetorically, if the horse is no worse off and better off for the exercise, that I have no claim at all? But that would be the consequence of my learned friend's analysis, because she would say the deceit claim, the claim in the tort of deceit fails, because the horse isn't worse off and actually better off. And you can't get user damages because you did consent to the taking of the horse, albeit that you did so because you were induced to do so by fraudulent misrepresentations.
Well, Lord Shaw expresses the principle extremely widely in 27, doesn't he? Wherever an abstraction or invasion of property has occurred. That's not limited by cause of action.
No. We
or
respectfully
indeed the
agree.
nature of extraction or invasion.
We respectfully agree. And another point which reinforces what your lordship just put to me is if we look just below line H, Lord Shaw says, keeping his horse standing idle in the stable and be against his wish or without his knowledge. So there are alternatives. It can be without my knowledge, the taking of the horse, or it could be against my wish. So presumably, if somebody holds a gun to my head and says, your horse or your life, and I say, fine, take the horse, then that would fall within the against my wish limb of the principle. But how does that map onto my learned friend's distinction between just taking property and acquiring it on terms which are objectionable? Ultimately, we say that's not the distinction which determines whether you get user damages or not.
Well, if we're picking on bits of text, I mean, again, we have at 92 Lord Reed looking at the position in breach of contract, refers to where the claimant has in substance been deprived of a valuable asset.
Indeed.
So we're getting quite a broad picture here of it's wherever there's an abstraction or invasion of property, including where it is in substance being deprived of a valuable asset, not in fact deprived.
Yeah. I confess I hadn't picked up the significance of in substance, but we respectfully agree that that is a pointer in the same direction. And I should just say before I move on, in argument below, one of my learned friends, well, one of her points was the tort of deceit. She said, imagine that somebody by fraudulent misrepresentation acquires property. She said, can it really be the case that you can get user damages? Mr. Turner Casey, the chair, he said, well, we don't know the answer to that. There's no authority on that. So to pose that analogy is just to move one difficult problem into another difficult problem, which we respectfully agree with. There isn't any case that says that you cannot get user damages in the tort of deceit. And since the example was deployed below, we've looked for authority. There is one authority, which is all we've been able to find, an Australian case, which says that you can get user damages in some circumstances for misrepresentation. I'll take your lordships to that tomorrow probably. It's the Larrikin music case. So it just goes to show that the boundaries of user damages are unclear, as Lord Burroughs himself says after One Step and Morris Garner. Nobody's identified any case that says you can't get user damages for deceit, or if property is taken pursuant to a contract, the terms of which are objectionable. And so we do say, unless my learned friend can make good her primary case, which is your lordships are bound by authority to allow their appeal, it's hard to see how this is the sort of thing that could be the subject of summary determination. So I was going to turn then to issue 1, which is there actually binding authority? Because as I say, that seems to us ultimately to be Meta's main point on this appeal. Now, my learned friend's case is that your lordships are bound by Vass and Devenish to hold that user damages can never be awarded for a non-proprietary tort. So I just want to I begin by identifying the precise proposition which is said to be binding. It is that the interpretation in Devenish of Vass is that you cannot get user damages for a non-proprietary tort. That's what's put forward as binding authority. I think it's paragraph 28, subparagraph A of my learned friend's skeleton argument.
Well, I think it was clarified that it's being said that WAS is independently binding on it.
Well, indeed. We hadn't understood that to be the case, but I mean, I'll meet it. My submissions on it are the same, but your lordship is right. Now, just to give your lordships our headline answers to this before I get into the detail, we say two things. First, neither Vass nor Devenish, properly analysed, says this, namely that you can only get user damages for non-proprietary torts. Second, if it does say that, that is either no longer good law or no longer binding, in the light of subsequent Supreme Court authority, among other things. Now, to try to make that good, my lords, what I need to do, if I may, with your lordship's permission, is to look closely at 4 key authorities which bear upon this question. They are Vass, Attorney General and Blake, Devenish, and One Step and Morris Garner. And I'll start with Vass, if I may, which is Authorities, Volume 1, Tab 6, page 81. Now, since my learned friend helpfully took the court through the passages in Vass, I think I can simply make my submissions without going through the passages again. We say that there are, I'll take Lord Justice Norse's judgment first and then Lord Justice Nicholas's judgment, because they actually differ in some respects. We say that there are 3 reasons why the judgment of Lord Justice Norse is not authority for the central proposition Meta advances on this appeal, namely that user damages can never be awarded for a non-proprietary tort. The first and in some ways simplest perhaps of our 3 points is that Lord Justice North did not actually say that anywhere, that you can only get user damages for a proprietary tort. Neither in their written submissions nor in my learned friend's submissions today has Meta been able to identify any passage in which Lord Justice North actually says that, even by implication. And as my Lord Justice Phillips observed in the course of argument, nor did Lord Justice North say that the exceptions are closed or exhausted. On the contrary, he considered making a further exception on the facts of VAS itself. That's the point the tribunal also made in its judgment, para 31. And we respectfully agree with it. So that's the first of our three points. Secondly, my lords, there's actually an even simpler reason why Lord Justice North's judgment can't be authority for the proposition that user damages are available only for proprietary torts, and it's this. If one looks carefully at VAS, the right in question, which the council was asserting, was a statutory right to hold a market under Section 49 of the Food and Drug Act 1955, which is now Section 50 of the 1984 Act. But what is significant is that right, that statutory right to hold a market, is actually proprietary. It is an incorporeal hereditament. So if Lord Justice North had said, as my learned friends contend, that user damages cannot be recovered for a non-proprietary tort, that wouldn't explain the actual result in the VAS case on its own facts, which was that user damages are not available for a market right infringement. In other words, for a proprietary tort. Just to give your lordships a reference to an authority that a statutory market right infringement is a proprietary cause of action, it is Spook, Erection and Secretary of State, a judgment of Lord Justice North himself, with the concurrence of Lord Justice Mann, who was also in the VAS case. That's Authorities Volume 2, tab 22, page 638. And there's another authority which helpfully summarizes the law on this. It's an article by Barry Huff, if I can show your lordships that. Authorities Volume 5, tab 54.
Just assume you're correct in all of this.
Yes.
Where does it take you? So the right which was violated was a proprietary right.
If that's right, where it takes me, my lord, is that suggests that VAS cannot have said that you can get user damages only for a non-proprietary tort, because that then wouldn't explain why the claim in VAS itself failed, which is what my learned friends are seeking to get from it. Or to put it another way, my learned friends say that what VAS is authority for is that user damages are available only for proprietary torts. On the facts of VAS, the claim for user damages failed. That's common ground. But if the tort being pleaded in that case was proprietary, and that's what I'm seeking to establish, then it's very unlikely that the case is...
They didn't... I don't remember, you'll tell me if I'm correct, they didn't analyse it in these terms. You're adding the statutory gloss and the analysis of the statutory right as an incorporeal hereditament. I seem to remember they described it as an invasion of a statutory right by nuisance or trespass.
That's right, but there's another passage where Lord Justice North, and I was going to take your lordship,
Okay.
but he does say that it's an incorporeal, it's a property right.
Okay.
And it's actually also picked up in Devonish, where Lady Justice Arden says...
Okay.
So
it's a property right, yet it failed.
Yet it failed. Which suggests that what VAS is saying must be something else. Not that you can only get user damages for proprietary torts, which is the target I need to meet.
That it failed for what reason? That so it was a proprietary right, yet it failed.
Yes.
And on that basis, precisely why did it fail?
And I'm going to come on to explain to that, but to answer, give your lordship a summary answer now. it failed for different reasons in the two judgments.
Yeah.
It failed in Lord Justice Nichols's judgment because he said user damages are inappropriate for this type of market right because it doesn't confer a right of exclusivity. Lord Justice, it's less clear why it failed on Lord Justice Norse's analysis. As we read it, it appears to have failed because Lord Justice Norse was concerned that if the claim were to succeed, it would, as he put it, revolutionize the law of tort by allowing you to get gain-based remedies for things like an infringement of a right of light and other aspects of the tort of nuisance. It's a sort of floodgates point in Lord Justice Norse's judgment. But my submission, I suppose, is a narrower one, which is it did not fail for the reason my learned friends seek to extract from the case, which is if the cause of action you advance is non-proprietary, then you can't get user damages. The article I wanted to show your lordships, if I may, it's Authorities Volume 5, tab 54, page 2164. If we go, please, to page 2167. So picking it up in the second paragraph, markets are classified as either lawful or informal. This distinction has been fundamental to the law. At common law, lawful market, properly so called, is a right of property, an incorporeal hereditament, which embraces certain incidents or rights of market. Then in the next paragraph, the right to hold a lawful market can arise in either of two circumstances. First, it can arise under the authority of a royal grant. This is normally a charter, although sometimes the grant is effected by letters patent. In either case, a franchise of market is established. Secondly, lawful markets can also be created under statute. And just pausing there and looking at the footnote, your lordships will see in footnote 13, there's a reference to section 50 of the Food Act 1984. That is the right which was an issue in VAS, albeit under the predecessor legislation. And then going back to the final paragraph on this page, in sum, a royal grant or a statute creates a property right entitling the owner to operate a market having certain legal incidents, and various authorities are cited for that proposition in footnotes 15 and 16. But I need to deal with the point my Lord Justice Green put to me, which is, am I superimposing this on Lord Justice Norse's reasoning, or is it reflected in his Lordship's reasoning?
It could be that even if there's a property right, user damages are still not necessarily appropriate.
And that may well be right, and we have never quarrelled with that. Our point is simply, there's no bright line exclusionary rule. Indeed, there may well be types of property rights where the logic of user damages doesn't run in an individual case, and that may well be right. But if we just look at the judgment itself, sorry to jump back and forth, Authorities Volume 1, tab 6. If we look at page 90, picking it up just above line G, Lord Justice Norse says, on a superficial view, the trespass cases present a greater difficulty. In trespass, the defendant makes an unlawful use of the plaintiff's land. Similarly, it can be said that in levying an unlawful rival market, the defendant makes an unlawful use of the plaintiff's right to hold his own market, which at any rate, in the case of a franchise market, is an incorporeal hereditament. He then poses the question, should it make all the difference that in the first case, the trespass case, the unlawful use is a physical one? He then describes that as a formidable line of argument, refers to the Vayleave cases, and ultimately says that despite that, you can't get user damages. And to answer my Lord's question, one sees the reason for that. Page 91, picking it up at line D, suppose a case where a right to light or a right of way had been obstructed to the profit of the servient owner but at no loss to the dominant owner, it would be difficult in the application of the user principle to make a logical distinction between such an obstruction and the infringement of a right to hold a market. And yet the application of that principle to such cases would not only give a right to substantial damages when no loss has been suffered, but would revolutionize the tort of nuisance by making it unnecessary to prove loss. Moreover, if the principle were to be applied to nuisance, why not in other torts, where the defendant's wrong can work to his own profit, for example, in defamation? So it's a sort of floodgates point. And then finally, at the bottom of that page, if we look at line H, if we had to allow that, why not also in the case of another day market where no loss had been proved? It is possible that the English law of tort, more especially of the so-called proprietary torts, will in due course make a more deliberate move towards recovery based not on loss suffered by the plaintiff, but on the unjust enrichment of the defendant. But I do not think that that process can begin in this case, and I doubt whether it can begin at all at this level of decision. So in our submission, the reason why on Lord Justice Norse's analysis the claim failed on WAS was not the nature of the cause of action, which actually was proprietary, but a concern that to allow the claim would then force the court to allow it in various other contexts which Lord Justice Norse thought to be inappropriate. And one reason for that, jumping ahead slightly, is that this whole analysis is being undertaken on the basis that user damages are restitutionary in nature, because that was the understanding of user damages at the time. Hence the reference in line H at page 91 to whether the English law of tort will move in due course towards recovery based not on loss suffered by the plaintiff but on unjust enrichment. And one can see that if you conceptualize user damages as a species of restitution, then there is a concern about floodgates. Because if you allow it in this claim, can somebody else in some other tort claim say, well, I haven't suffered any loss, but I want to get your profits? But what this is not saying is that you can't get user damages for a non-proprietary tort. Indeed, finally on this point, my lord, I would just make the point that the Spook case, Spook Erection and Secretary of State, the case I mentioned, the judgment in that case was given by Lord Justice Norse, which says that a market right is proprietary. The appeal in that case was heard on the 21st of April 1988, which is just a month before the appeal in the WAS case was heard, and Lord Justice Mann was a member of the Constitution in both cases. So it is in our submission unlikely that Lord Justice Norse and Lord Justice Mann decided the WAS case on the footing that user damages cannot be recovered for a non-proprietary tort. So that's point 2, so far as Lord Justice Norse is concerned. Our third point, I'm so sorry, my lord, I've completely forgot about the transcriber break. I didn't know whether your lordships would wish to take that now, or whether I should just press on and finish. I'm in the court's hands.
5 minutes. Come back at 5-2.
I thank you for explaining it. I agree with you about the narrative, and I should think I should give compensation. I have the $50 on your screen, because you would have somehow. Wow, marvelous. Thank you.
I will do that. I want to see.
We'll see tomorrow. Yeah. I'm grateful, my Lord. I'd address the first two of the three reasons why we submit that Lord Justice knows his judgment in Vass is not authority for the proposition that my learned friends seek to derive from it. The third point is this. Lord Justice Norse regarded user damages for trespass and for the breach of a restrictive covenant as restitutionary in nature, not compensatory. And one can see that if we go back first to page 86, Authorities Volume 1, tab 6, page 86. Just below line G, Lord Justice Norse identifies a general rule where he says the general rule is that a successful plaintiff in an action in tort recovers damages equivalent to the loss which he has suffered, no more and no less. That's the compensatory principle. But he then says there are exceptions to that and also his second general rule. And if we go to page 89, final sentence, at the bottom of page 89, one sees that the learned Lord Justice regarded trespass and Rootham Park as exceptions to that general
Can I
rule.
just pick up below H?
Yes,
The authorities establish that both these rules are subject to exceptions.
yes.
They must be closely examined in order to see whether a further exception
Ought to be made in this case. This is the point about further exceptions.
Yes, indeed. Which itself is inconsistent with the existence of any closed list. And then Lord Justice North identifies the exceptions. He identifies 5 different exceptions. You should just prove. Principle without proof of loss. In all other cases, the plaintiff having established his loss, the real question has not been whether substantial damage should be awarded at all, but whether they should be assessed in accordance with the user principle. Then he says this, in other words, these other cases are exceptions to the second but not to the first of the general rules stated above. So what the learned Lord Justice is saying is that of the 5 exceptions that he had identified, 2 of the exceptions are exceptions to the first general rule, namely that damages in tort are meant to compensate the claimant for the loss that he has suffered. And those 2 exceptions are trespass and Rootham Park. The reason I draw attention to that is in our respectful submission, that analysis cannot survive one step. Because the Supreme Court expressly says that damages, even in those 2 instances or categories of case, are compensatory, not restitutionary, and an application of the compensatory principle rather than an exception to it. I'll go back to one step in due course, but just to give the court the references, these 2 categories of case, which are analyzed as compensatory, that is at paragraphs 30, 69, 91 and 95 of one step. And so while my learned friend was right to make the point that the Vass case is cited in one step, it is significant that the Supreme Court only cited the judgment of Lord Justice Nichols and not that of Lord Justice North in one step. So they refer to Vass 3 times in one step, paragraphs 29, 110, 133, but in all 3 instances they refer only to the analysis of Lord Justice Nichols, not that of Lord Justice North. So the third of our 3 points is that an important element of Lord Justice North's reasoning appears to be founded upon a characterization of user damages, namely as restitutionary rather than compensatory, which the Supreme Court has subsequently rejected. That's all I wanted to say about Lord Justice North's judgment. Turning then to Lord Justice Nichols's judgment, we say it's even clearer that Lord Justice Nichols did not endorse the non-proprietary tort limitation for which my learned friends contend. Lord Justice Nichols actually decided the case on a narrower basis than Lord Justice North. He said that a market right under the 1984 Act is a right to operate one's own market without disturbance, but does not confer any exclusivities One can see that at page 94, letters G, I'm picking it up first at just above letter D, page 94. Lord Justice Nichols begins by saying, just above letter B actually, in the present case, the Council seeks to extend the user principle by applying it to a case of disturbance of market rights. He then notes that there's no previous case in which that extension has been made. Then he says, just above line D, the common law, however, is constantly being developed and adapted as social conditions change, and novelty by itself is not an answer to the present claim. Pausing there, that itself might be thought to be a difficulty for my learned friend's case, especially on the equivalent of a strikeout application. Lord Justice Nichols then says that he was for some time attracted by an analogy between the infringement of a patent and the infringement of a market right. Because, of course, by this point in the history, it has become established that you can get user damages for patent infringement, hence the analogy. But he then says, starting at line F, that the analogy is unsound, and he explains why it's unsound. It's unsound because a market right confers a monopoly, as does a patent, but the protection which the law affords to the owner of a market right is limited to protecting him against being disturbed in the enjoyment of his right. If an unauthorized market is held without disturbing the lawful market, the owner of the lawful market has no remedy, either for damages or otherwise. So there's nothing there that contains any general proposition that you can never get user damages for non-proprietary tort. And indeed, as I think my Lord Justice Phillips observed in the course of my learned friend's submissions, Lord Justice Nichols expressly declined to identify the boundary. One sees that at page 96, lines B to C, the last page. He says, wherever precisely the boundary separating causes of action in which the user principle will be applied from those in which it will not is to be drawn, for the reasons I've sought to state, that principle has no application to a cause of action for disturbance for market. So for those reasons, we submit that neither the judgment of Lord Justice Knowles nor the judgment of Lord Justice Nichols says that you can get user damages only for a non-proprietary tort. Indeed, the interesting thing about this part of my learned friend skeleton argument is that it's co-bundle tab 9, page 93. Perhaps I should just turn that up. Tab 9, page 93. At the top of page 93, they're discussing the Vass case. And your lordships will see various references in the footnotes to passages from Vass. So footnote 13, 14, and so on. But the only sentence that doesn't have a footnote is the one about halfway into the paragraph. It says, the Court of Appeal unanimously held that user damages were not available because user damages are only available for proprietary torts, and the cause of action being advanced was not a proprietary tort. Your lordships have my submissions about why neither of the two substantive judgments in the case says that or even implies it. So that is Vass. I was going to turn next to Attorney General and Blake, which it's important to look at because, as we'll see when we come to Devonish, various passages in the judgment of Lady Justice Arden, on which my learned friend relies, were influenced by Blake. And one of the key issues in Devonish itself was what is the impact of Blake on the availability of restitutionary remedies in the law of tort. Now, Blake is at Authorities, Volume 2, tab 26, page 687. Just to summarize the facts very quickly, my lords, George Blake, of course, had been sentenced to 42 years in prison, but escaped from prison and fled to Moscow. And the issue in this case was whether the Crown was entitled to an account of profits for a breach of contract by Blake in publishing his autobiography. It had to be put as breach of contract because by the time he published the autobiography, the information in it had ceased to be confidential, so there was no claim for breach of confidence. One sees that at page 696, at letter H. Where Lord Nichols, who gave the leading speech, says, "The matter was pursued in your Lordship's house. Prompted by an invitation from your Lordship, the Attorney General advanced an argument that restitutionary principles ought to operate to enable the Crown to recover from Blake his profits arising from his breach of contract. It will be convenient to consider this private law claim first." He then notes there's very little authority on this. And that may be why what Lord Nichols does before he comes to consider breach of contract, which is what the case is about, he considers three other areas of the law by analogy, one of which is interference with rights of property, and one can see that at page 697, line D. Just above that, there's a heading which says interference with rights of property. In the third line, Lord Nichols says, "As with breaches of contract, so with tort, the general principle regarding assessment of damages is that they are compensatory for loss or injury." There's a reference to Livingston and Royards. Then just below line E, Lord Nichols says, "But the common law, pragmatic as ever, has long recognized that there are many commonplace situations where a strict application of this principle would not do justice between the parties. The compensation for the wrong done to the plaintiff is measured by a different yardstick. A trespasser who enters another's land may cause the landowner no financial loss. In such a case, damages are measured by the benefit received by the trespasser, namely his use of the land." A significant sentence, because there, Lord Nichols is analysing what we are calling user damages for trespass to land as a benefit or gain-based remedy, a restitutionary remedy. And then there's another, at the bottom of that page, there's a reference to the mediana. Over the page, at page 698, there's a reference to the patent infringement case, Watson-Laidlaw, which we have looked at. Then there's this important passage starting at line D, and I wonder if I can invite your lordships, please, to read that, and then I'll make a submission about it. The passage starting with the words, "This principle is established and not controversial," page 698, lines D to E. I'm grateful. So what Lord Nichols is saying in that passage is that the award of user damages in the categories of cases just discussed, namely trespass, patent infringement, and debt union, is difficult to reconcile with the basic compensatory measure and should be regarded as an exception to the general rule that damages in tort are compensatory. That's the last line in that passage where he says, such awards are probably best regarded as an exception to the general rule. And 3 or 4 lines above that, he says, however that may be, these awards cannot be regarded as conforming to the strictly compensatory measure of damage for the injured person's loss. And then this is the important phrase, unless loss is given a strained and artificial meaning. Now, one might ask, why is Lord Nichols analysing the nature of user damages in tort, given that Blake is a contract case? He's doing it because if user damages in the law of tort are properly analysed as restitutionary rather than compensatory, then they could be a stepping stone for the award of other restitutionary remedies for breach of contract, such as an account of profits, which was what was claimed in Blake. And one sees that if one goes to page 701, where the discussion of breach of contract begins, And then at page 702, near line H, Lord Nichols refers to Rootham Park, and at the bottom of the page says, the Rootham Park case therefore still shines rather as a solitary beacon, showing that in contract as well as tort, damages are not always narrowly confined to recoupment of financial loss. In a suitable case, damages for breach of contract may be measured by the benefit gained by the wrongdoer from the breach. The defendant must make a reasonable payment in respect of the benefit he has gained. So just pausing there, my lords, Lord Nichols's reasoning in Blake was that user damages and an account of profits belong in the same box, as it were, in that they are both gain-based or restitutionary remedies on a sliding scale, with user damages taking away some of the benefit the defendant made, whereas an account of profits takes away all the gains that the defendant made. And this, of course, that analysis has long been adopted by various academic commentators, because the preferable view before one step, or certainly the dominant view, was that user damages are restitutionary in nature, but they strip away some of the profit, and an account of profit strips away all of the profit. And just for your lordship's note, Lord Burrows, writing extrajudicially, has pointed out that Lord Nichols in the Blake case treated user damages as restitutionary in nature for this very reason. That is Authorities, Volume 5, tab 58, page 2240. But just going back for a moment, if we can, to page 698, the passage I showed your lordship, starting with this principle is established and not controversial. The reason why I've placed some emphasis on that passage is that Lady Justice Arden relied on it in Devonish, but the Supreme Court in one step expressly cited and disagreed with it. And that's why I want to show your lordships that part of one step before we look at Devonish. One step is in the same volume, tab 11. Sorry, actually, Authorities, Volume 1, tab 11.
Just before we leave A.G. and Blake,
Yes.
what point do you deduce from it that helps you?
The point that I submit helps me is that Lord Nichols in Blake treated the award of user damages in tort as restitutionary in nature, not as compensatory in nature. The reason why I say that helps me, and this is what I'm going to develop now, is that it's that same restitutionary analysis of user damages that's been adopted by Lady Justice Arden in Devonish, but the Supreme Court has now said that that's all wrong. And they've said it expressly by citing the very passage from Blake we've just looked at. So that's...
And that then circles back for you to say at least one of the reasons that Was and or Devonish are not relevant is because they made a mistake as to the classification of user damages.
Precisely so.
That's the point, isn't it?
That's the point. So to put it at its lowest...
And we just take that from one stop.
Well, we could do. I just wanted to show your lordships that in Blake itself, but we could take it from one step because it's actually quoted in one step, this bit of Blake. Can I show your lordships that? It's Volume 1, tab 11. Page 289. Tab 11, page 289. This is where Lord Reed begins his discussion of what the Supreme Court is calling negotiating damages, but which is the same thing as user damages. There's a discussion of Rootham Park starting at 49, which I won't read. But if we then go to para 58, at page 292, Lord Reed refers to the judgment of this court in the Surrey County Council case. In that case, picking it up in the final sentence paragraph, it's necessary to refer to the case in the present context only because of Lord Justice Staines's comment that the Rootham Park estate decision was only defensible on the basis of restitutionary principles. The object of the award was to deprive the defendants of an unjustly acquired gain. At 59, Lord Reed notes that restitutionary analysis was rejected in Jaggard and Sawyer. And then over the page at 293, At paragraph 60, Lord Reed cites, as we read it without disapproval, an observation of Lord Justice Millett, which was, "It is plain from his judgment in the Rootham Park case that Mr. Justice Brightman's approach was compensatory, not restitutionary. He sought to measure the damages by reference to what the plaintiff had lost, not by reference to what the defendant had gained." And then if we come to para 64, he considers the Blake case, which we just looked at. And then could I ask your lordships please to read 65 and 66 at page 294, which is where he deals with the passage we looked at from Blake.
Yeah, and then it's paragraph 30, which we've already looked at.
Precisely.
And that's all you really need to know, at least for the purpose of arguability, that we're not dealing with a restitutionary claim, we're looking at a compensatory claim, and at least arguably in treating user damages as restitutionary in Was and in Devonish they were wrong.
Precisely. Indeed, my lord.
Does it go to anything more than that?
That's what it goes to. Because what I'm trying to meet is the suggestion that your lordships are bound by.
No, we understand. Yeah, we got that.
And I'm mindful of the time. The only point I wanted quickly to draw your lordship's attention to is page 295, at the top of the page. There is a citation, 2001 1 AC 268, 279. Page 295 of the bundle, in Lord Reed's judgment, top of the page, there's a reference to 2001 1 AC 268 279. 279 contains the passage which I just took your lordships to, which the Supreme Court is disagreeing with from Blake. And just to give your lordship a reference, there's another disagreement with Blake at para 72, but I don't need to read that. That's the solitary beacon passage, and I wonder if that's a convenient moment. I'd assumed your lordships would be sitting till 1/4 and not 1/2.
Yeah. Right for 1/4. Yes, that's fine. We can sit at 1/4 tomorrow. Sorry.
Oh, sorry, no, I was just saying that I had assumed your lordships would be sitting until
Oh, is he 1/4 today?
Today, because
Yes, unless you want to continue. I mean, is that an appropriate moment? Put it that way.
I think so. I was going to turn to Devonish, and perhaps I can do
Okay,
that tomorrow.
right. Tomorrow then.
I'm great.
10:30.